So hey, it's Brian Barker, your old friend, coming at you with the good stuff. I did a video on written disputes, how to dispute a written letter, and how I thought the letter that comes in most forms from most debt collectors, which is driven by the government telling them how to send this letter, is not good. It's a checkbox mentality, which is good when I'm giving you checkboxes of everything they're gonna do, and it's usually lengthy. The letter in that written video about the written information you receive says, check one box if you dispute this. We don't do that. But what I want to do is handle verbal issues. So when you get a call from a debt collector, how do you handle that? Remember, most calls, whether you're calling them, they're calling you, the debtor, the consumer, is fearful. It's a big machine. So look for my tips on how to handle verbal calls. So if you know you're getting calls and you want to know how to handle them, use my tips. I'll give you a defense checklist for both written and verbal communications from a debt collector, including at the end of this video, an incident where a client of mine, by paying $200 on a debt she didn't verify or get valid, it's all good, has led to over $10,000 in costs and fees battling the case that normally I would just get rid of. But because she made these payments, I see this in litigation up and down the court system. We've taken this to appeal. Finally, it's back to the original court where it belongs, and we're litigating, and we're doing great now. But because she paid that $200 when she got sued, it's ended up costing a great deal more. I'm gonna tell you how not to make that mistake. So let's talk about verbal contracts. You get towards this $200 mistake that costs $10,000. So remember, fear is a paralyzing force. It's emotion. And a debt collector is pursuing you, that promotes fear. They act on that. So you're already on your heels when you're maybe calling them or receiving a call. So verbally, they must say, this is an attempt to collect a debt. Anything you say will be used for that purpose. Anything you say, so in a verbal context, don't say stuff that's gonna get you into trouble, right? So I'm gonna give you a way to stay out of trouble. 4 words. I dispute the debt. That's it. No matter what happens, they call you, I dispute the debt. You don't have to care whether they think you sound crazy or like a robot. Remember, you're also being taped. I dispute the debt. I dispute the debt. I dispute the debt. Me? I dispute the debt. Have you got the right person? Don't care what the other side thinks of that, because what you say hurts you, you'll hear it. So heavily laden your conversation with I dispute the debt. Otherwise, your mistakes have heavy legal consequences. Here's what happens under the law if you verbally dispute the debt. Shazam! Under the Fair Credit Reporting Act, Section 623A3, if you dispute a debt in any form, including verbally over the phone, the debt collector must report the dispute to all credit bureaus where they reported the debt. Disputes can even stop whatever debt is on your credit report from being part of the lowering of your FICO score. So always dispute. Here's the actual rule. If the completeness or accuracy of any information furnished by any person to any consumer reporting agency is disputed to such person by a consumer, hello, I dispute, the person may not furnish the information to any consumer reporting agency without notice. Things happen. They'll report that you owe the debt and not do that dispute. That's an action against them right there. So when talking to a collector, please remember this. Say this: we will use any information you give us to help collecting a debt. All right? We will use any information you will give us to help collect a debt. That's the Mini Miranda warning. So anything you say to them, what will they do with it? Use it to collect the debt. That has legal consequences down the road. Remember, the $200 that costs $10,000. So when you receive a call, I dispute. And then you say, I want your name, your employee number, ask for the address of the debt collector, because that's information they should be giving you anyway for you to send the letter. Don't be on your heels. You ask that question to take control. Fear eliminates control. Whenever you fear, you eliminate control. You fear something, you are not in control. So emotion also eliminates control. When I'm in battles in court, I take a deep breath. The minute I start getting emotional, and I do, because I'm better as I got older, but emotion screws you up, man. Write this stuff down. I'm gonna do a checklist for you. So if they give you a hard time, this is a key about giving you information when they're asking you for information, that's a hint to you that this is not a fair distribution of information. It's not an equal footing here. So be on alert, right? They have a script. They have to follow a script. It's AI driven. It used to be somebody's created. It's now AI script. They're filling in boxes and AI is telling them what to ask you depending on what you say. Frustrate them. Ask them to keep asking them to repeat what they said. There's no rule against seeking clarity. What if you heard it wrong and you answer based upon, and I've done depositions where this happened, and you answer based on what you thought you heard. Keep asking them to repeat. It'll piss them off. It'll frustrate them. They'll get mad, but they'll get off script. And you're not someone that has to be putting up or tolerating a script, all right? Tell them you're having trouble hearing them. You want to hear what they're asking you. There's nothing wrong with that. Make sure you may want to say that. Keep a date of all the information you receive and what you advise the collector and who you spoke with. Please write that down. Never admit anything. They called you. A lot of times you'll say, hey, I want to settle this debt, work this out. And they'll go, okay, just give me this information. Is it you, security number, your address? That's all being used against you. It's going to be used against you. If I may, I can repeat the Mini Miranda. Anything you say will be used to collect the debt. Please keep that in your head. Anything you say, right? So don't give them anything. And if they say, well, I can't tell you what you owe and why you owe it until I get this information, said, call me when you can. And then you be nice. You go, I'm asking you one more time, why do I owe the debt? I dispute this. Please tell me. Why do I have to give you information to receive information? You called me. Never admit you owe the debt, right? Don't agree with anything. Don't. They say something and they go, okay? Don't. That okay is, I'm legally holding you responsible. Okay? Question, you're responsible now. So you want to know about the $200 mistake that cost thousands of dollars? Okay, so a client gets sued by Velocity. What she did is, like it's a normal thing, called up the debt collector. Do you have the right person? Da da da. They go, you owe this. We're suing you. Blah blah blah. And for some reason, and it's common, if you just pay a little, we know you're going to show good faith here, and that way we can, we'll back off. They never do. So she said, well, here's $200. I don't know who you are, but here's $200. So this is gone up to the Court of Appeals a couple of times now because. And this is what I have to read every time in their responsive briefs. Shazam. This is just the defendant's action. Just like the defendant's actions at the case of bar. Defendant appellant's assertion. Appellant means we've appealed it. It's in appeal now. Ring hollow and appear disingenuous. The defendant knew the plaintiff Velocity was the assignee of her debt. She didn't. She's just scared out of her mind. On April 4, 2023, the defendant entered into a loan payment agreement with plaintiff and made a payment of $200. I hear that on every motion up and down the Court of Appeals and Circuit Court. I've got to hear that. By the way, payments don't mean they own it, but it shows a lot of judges go, well, I guess she owes it and she paid it. So that's more work I've got to do. I've put in over $10,000 of my time defending that because of that $200 that normally you just settle for a little debt elimination. So all this is on killdebt.com. Use Parker GPT. It's all embedded. Attached to this video will be validation letters for you, cease and desist letters, show notes, a checklist on what you can do with collection letters and handling verbal context. So I love my checklist. My checklists are for you. That'll be embedded in Parker GPT too. But use that checklist. You can have it right next to you when you're receiving calls or if you receive a letter. Let's take a look at Parker's checklist. It works for you, but go to Parker GPT. It's less than 1/10 of what you'd pay an attorney to defend these things, because defend these things you will if you don't do the right thing. And even if you do 100% of the right thing, You still may be pursued, but now you've got all this great evidence because you did the homework. You followed Parker's rules on handling debt collector letters and calls. I hope this helps. You're the best.